Are employment bonds or minimum term clauses legally enforceable in India? Employers often use them to prevent early attrition and recover recruitment and training costs. But what does the law say? It's common for employers to require employees to serve a minimum term, say 2 or 3 years, failing which the employee must pay a preset amount to the employer. What is the aim? The aim is to reduce attrition and recover investment in hiring and training costs. But employees often challenge these clauses under Section 27 of the Indian Contract Act, arguing that it restrains trade, and/or Section 23 of the Indian Contract Act, claiming it's against public policy. However, Indian courts have made key distinctions. Restrictions during employment are treated differently from those which arise after employment. A minimum term clause or bond may be upheld if the duration is found to be reasonable, the penalty reflects actual training or recruitment costs incurred by the employer, and the agreement was made with free consent, that is, without any coercion or undue influence. Take the recent 2025 Supreme Court ruling in the Vijaya Bank's case. The court allowed the bank to recover Indian rupees 2 lakh after the employee quit early. It found that the 3-year minimum term clause reasonable and tied it to the financial hardships which the public sector bank would suffer due to untimely recruitment drives owing to the premature resignation by the employee. But the important caveat is that this case involved public employment. Strictly speaking, it may not directly apply to the private sector. Even with a bond, employers can't automatically claim damages from the employee. They must prove actual loss considering various factors like recruitment and training expenses incurred, seniority and the role criticality, impact of sudden exits, lack of quick replacements, and sectors directly involving public interests like the aviation sector. So what is the bottom line? Minimum term clauses and employment bonds can be enforceable, but only if they are fair, reasonable, and evidence-backed. Needless to mention, it would depend on the facts and circumstance of each case. Employers should seek legal advice proactively before drafting such agreements to ensure that they are aligned with both the law and the business needs.